So this is the last lecture, you guys, before break. I would assume that you're all about ready to go absolutely nuts. So make a cheat sheet, right, for the quiz, please. Get all the court cases, get all the vocab, get all the ideas. One side, 3 by 5, okay? And you're probably going to want to watch it again after, maybe during break, to go back and study, to really be prepared for the AP exam, because I know you guys are busy. You got things due tomorrow, you got tests tomorrow. All right? But we have a quiz tomorrow, all right? We'll eat some pizza, have some discussions, and take a quiz. All right. So this idea of equal rights, right? We've got to think about how people are treated in society based upon what they are. We have race, we have gender. I think now more than ever, especially with same-sex marriage, we have this idea of sexuality now in some way, shape, or form, how people are treated, right? So race, gender, I guess groups that are other than, white male Protestants, right? I mean, that has been the dominant power authority throughout the Western civilization. And so there's been, this struggle for equal rights among other groups, right? And I think the thing that's just interesting is take a step back, right? To think that this is only an American issue. Every society in this world has these issues: discrimination, equal protection under the law. They have discrimination issues, right? I mean, any society has minority groups. Any society has gender issues. Maybe some are more, at different stages, but this is a human problem, right? So don't view it just in America, right? This is definitely a human problem, all right? So, and I want to quickly go over 13 and 14 because I really believe those are something that are straightforward, and get into 15 and 16 for you because that's the kind of constitutional stuff. So make sure you're going through this and looking at the legislation, right? Looking at the kind of movements, right? But if we look just at gender, all right? Gender, we see this big push, the 19th Amendment, right? To get women the right to vote. And you don't have political power, you don't have a political voice until you can vote in a democratic society. Right? And so again, that's 1920, right? I mean, what? 80-something years, 60-something years after African Americans are given the right to vote, right? Even though what you're going to see is even though African Americans have been given the right to vote, they're really not voting in the South at this point still, even though it's the 15th Amendment, all right? So just really quickly, a couple things, right, that we see. Legislation, Equal Pay Act, Civil Rights Act of 1964 says no discrimination in employment based upon sex or gender, right? Title IX, which is something that you guys get fired up about, right? Which prohibits gender discrimination in federally subsidized, or subsidized means paid for, education programs, which the big deal is we generally see this in athletics, right? There has to be equal number of male to female athletes at universities, all right? And guys get mad at that. Girls are probably like, yeah, it's fair. All right. We have Roe v. Wade again, which is a woman's issue, right? One of the things too is like 1992, we see tons of women elected to Congress, right? The 113th right now is bigger than the 111th that's in your notes. All right. However, let's step back just a second. The Equal Rights Amendment, which is Roman numeral 1, letter B, number 3. C, the ERA, right? Proposal, ratification, struggle, and defeat of the Equal Rights Amendment. The Equal Rights Amendment was a proposed amendment to the Constitution that was going to say women will be treated equally under the law. It was gender specific. So one of the things they do on the AP test all the time is they want you to say that the Equal Rights Amendment was actually added to the Constitution. It was never added to the Constitution, and you have to be aware of that, all right? But the idea was, I think, it had this kind of struggle. It was proposed, it's been proposed in every single Congress, right? It's just in the 70s, it actually got the 2/3 proposal out, but it never got the 3/4 ratification, all right? It's still proposed in every single Congress, right? As women feel that there's still this glass ceiling they're bumping into, all right? Now, and I think, Equal Pay Act, we can look at some of these things and see that women are paid different than men for the same jobs. There's data to prove that, all right, or at least to show that discussion. All right, so gender, let's just think about gender, all right? Now, one of the things we also have to think about in this whole concept today is the Equal Protection Clause. You guys have met the 14th Amendment because of its due process clause and incorporation, selective incorporation. Now you have this concept, we go to the clause, Equal Protection Clause. No state shall deny any person, right, equal protection under the law. All right, that's a huge, huge, huge concept and a huge tool tool for, ending discrimination, or at least in this struggle for equal rights. All right, so gender. Now, African Americans, right, roughly 13% of the population. All right, now if we go through Dred Scott, I know you know Dred Scott, that basically said slaves weren't citizens and therefore don't have rights. All right, we get the Civil War amendments, 13, 14, 15. End slavery, 14th Amendment makes former slaves citizens. It also has the Due Process Clause, right? It also has the Equal Protection Clause, and then the 15th gives the right to vote to African Americans. All right, now we know that we get Plessy, which still says separate but equal. Now you got to think about that for a minute. Plessy interprets the Equal Protection Clause to mean, to set a precedent that says in 1896, what equal protection under the law means is separate but equal. That enables Jim Crow to exist in the South legally. All right? And then again, we know the overturning of Plessy in Brown, which redefines what absolutely exists as the interpretation of the Equal Protection Clause. All right? Now, what you're going to see here is resistance in E to de jure segregation. All right? De jure. De jure. All right? De jure is legal segregation. So what Plessy did is it ended legal segregation. No more Jim Crow laws, right? Now, here's another term called de facto segregation, right? Like legally, you cannot segregate, but people still do, right? Based on race, based on income, that kind of thing, right? De facto is that it just happens, even though it can't happen legally. And we're going to get into that a little bit more in class, all right? But, so we have civil disobedience, we have the civil rights movement, right? In the 50s, 60s, and late 60s, all right? And you have, African Americans expanding, fighting, struggling for equal rights, all right? Now, this concept of affirmative action, right? This concept of affirmative action, which we will get into a little bit more in class, all right? Eric. Mentor today?
Yeah.
Yeah, nice. Good job. So we have this idea of affirmative action. Now, we're going to go in class and talk about this a little bit more, but this idea of affirmative action was generated by the fact that even though African Americans, even though certain ethnic groups, they had been discriminated against in the past, they still weren't competing educationally, they still weren't competing economically, so they had this kind of political equality, but definitely not this economic or education equality. And so the idea behind affirmative action was to help assist discriminated groups get a chance to compete with the groups that hadn't been discriminated against, all right? And we'll talk about that in class, all right? But that's just the idea behind it, all right? Now, if we move on again, we have, Hispanics, again, about 17% of the population, right? How are Hispanics treated in American society, right? We have the immigration issue, but more importantly, or in addition to, the Hispanic population, is assimilating into the American, they're assimilating linguistically, they're assimilating economically, they're assimilating, right? And so what's interesting about the Hispanic group is, again, is there discrimination among Hispanics in this society, right? And we'll have that discussion a little bit, all right? But here's another thing I think about that. Is the Hispanic vote is important to the Democrats and the Republicans. There are things that make Hispanics conservative and things that make Hispanics a little more liberal. And, they're both fighting for that huge kind of demographic vote or block of voters, all right, to compete. And, again, as people, African Americans, as women, as Hispanics gain the right to vote, they become a political entity that politicians have to pay attention to, right? Okay, I mean, we had Southern senators that before African Americans could vote, they ignored them completely as far as legally goes, right? But as soon as African Americans have the right to vote, they turn and say, okay, they're my constituents. What do you need? What do you want? How do I represent you so I can get reelected? All right? And now, Asians, right? 5-ish% of the population. Now, the interesting thing about Asians, besides the World War II experience of Japanese Americans, right, is this idea of reverse discrimination. The model minority, this idea that Asians are competing economically, Asians are competing academically, Asians are competing in the business models, right? All right. So we have those kind of groups to look at this equal protection under the law, right? So let's flip to page 15. Now, discrimination. Discrimination just means treating somebody differently. All right? Now, some of it's inevitable, right? You get a driver's license when you're 16. You can't drink till you're 21, right? But here's the thing. look at the 14th Amendment's Equal Protection Clause bans governments, state and federal, right, from practicing unreasonable discrimination, right? But then we get into what is unreasonable, what is reasonable, all right? And so now, of course, we have a few tests, right? Now check this out as you go through the tests. Rational basis test. So here's the deal. Discrimination is constitutional if it has a reasonable relationship to a proper purpose of government. So, examples of things that have been acceptable. Polygamy, marriage age, prohibiting felons from getting teaching credentials, right? Like there's certain things they can say, if you're part of a group, you can't do this, right? If you have multiple DUIs, you can't get a driver's license ever again, right? Or if you've had a DUI, a company can say, we're not going to hire you to be a driver, right? Those are generally okay. Now look at this. Rational basis test cannot be used by the courts or applied if it involves a suspect class, an almost suspect class, which is called a quasi-suspect class, or a fundamental right, a fundamental liberty, right? Life, liberty, property. If one of your natural rights is involved, they cannot use rational basis because rational basis makes it easy to limit or to treat people differently. All right? Now let's go to suspect class. So a suspect class, look at the definition. A class that has historically suffered unequal treatment on the basis of race, national origin, religion, and I'm gonna say, sexuality at this point. All right? So that's what a suspect class is. And when there's a suspect class involved, they then use strict scrutiny rather than, right? They use strict scrutiny. I mean, they're really going to look at it and go, okay, why is that happening? You have race, you have gender, you have religiosity. Why are you doing that, right? Strict scrutiny. Okay, now, here's the deal. When government discriminates on this basis, or when somebody discriminates on the basis of a suspect class, all right, the government has to prove why they're doing this, all right? The courts subject that to strict scrutiny. Now, here we go. It's a religious term that we heard with the Establishment Clause, or free exercise. There must be a compelling purpose for that discrimination to be constitutional. A compelling purpose, right? If there's a suspect class involved. So, check it out. Affirmative action. You have Bakke. You have to know UC Regents versus Bakke. You have to know Gratz versus Bollinger and Grutter versus Bollinger. Check these out. So, UC Regents versus Bakke. You had Bakke, who was applying to UC Med School. He was a white guy. And he said that people of a suspect class, African Americans, Hispanics, were being let into UC Med School with lower test grades than him, with lower GPAs, and getting into med school when he had higher ones wasn't getting. He said there's reverse discrimination, right? So the government had to show why are they using race, right? And what they said is you cannot use quotas. I can't say, okay, there's 13% of the country is African American, so 13% will be in our medical school class. And for any group, you can't do that. But race can be one of many factors. So generally what that kind of said is, if you compete on the same level, race can be a factor. All right? Okay. And Bakke's huge. It's an affirmative action case. Now, go to Gratz v. Bollinger, right? And look at this. In Gratz v. Bollinger, they use bonus points for race. So think about this. The admin people were going, okay, here's this kid's SATs. They get so many points for the SATs. Here's this kid's GPA, so many points for GPA. Extracurricular, yada, yada, yada. And then they got to race and they said, okay, if you're a racial minority, they were giving bonus points for being a racial minority because they're trying to get, again, with this affirmative action, if you get one generation of a suspect class competing economically, then future generations will do it without the need for affirmative action. All right? Okay. And again, we're going to have more on this in class. Now, Grutter v. Bollinger said, again, race can be a factor, but not the only factor. In the one where they're giving points, why were you getting points? Only because of race. And therefore, you couldn't use it. All right? Okay. Now, let's go down to, and we saw racial gerrymandering with Shaw v. Reno, right? Race cannot be the factor when you draw those lines. It's reverse discrimination. Now, quasi-suspect class. These are women, right? Quasi-suspect class is usually gender. Now, they use heightened scrutiny. If there's a suspect class, strict scrutiny. A quasi-suspect class, heightened scrutiny. So it's not as much as strict scrutiny, but it's not as much as, a reasonable relationship on the rational basis test. All right? So check this out. Scrutiny for sex discrimination is not quite as high as race in recognition that there's some biological difference, right? Maternity leave or pregnancy leave for women is okay, but not for men. We don't get pregnant, right? There's that Arnold Schwarzenegger movie where he gets pregnant, which I don't know about it, all right? But, so some differences, right, is okay. But here's the thing. Look at number 3 here. To justify discrimination on the basis of gender, quasi-suspect class, the state must show that it bears some relation to important government objective. You can't say, women aren't as strong, women aren't as smart, women aren't as, they should be here, they should be there. You can't use that for that, all right? So, like a male-only draft has been allowed at this point. Like 15 minutes, 10 minutes, 10 minutes, 10, all right? So, quasi-suspect classes use heightened scrutiny. Now, let's back to the last page because I know this is getting long. The fundamental rights test, okay? So, if somebody is taking away a fundamental right, the court will apply strict scrutiny. Religion, speech, press, assembly, etc. They're applying strict scrutiny to this, all right? And fundamental rights are those which are explicitly stated in the First Amendment liberties as well as voting, all right? Privacy, which is in Griswold, all right? Now, again, we talk about Roe. Let's just really quickly look at Roe, all right, for just a second. And then I think that's it. You guys can look at the other ones and figure it out. So, is the right to privacy a fundamental right? Most people would say yes, all right? But again, we've looked at Roe, all right? We've looked at Roe a number of times, actually. We're going to rip right through this. The idea here is Roe said that based on the precedent in Griswold, you have the right to privacy. Giving abortion is the private decision, therefore falls under the right to privacy. So states cannot deny access in the first 3 months, the first trimester, to an abortion for a woman. No state law. Prior to that, each state did their own thing, all right? Okay, now, there's 3 cases here, all right? Webster versus Reproductive Health Services. Look at this. It didn't overturn Roe, but it gave states more leeway in restricting abortion. They still protected that first 3 months, but after that, they allowed states to have a lot more, to write their own laws restricting abortion. Now, check this out, though. Planned Parenthood v. Casey in 92. It defined leeway, because the problem is, if you say leeway, what's leeway, right? In the Webster case. So check this out. States cannot impose an undue burden on a woman's right to an abortion. You had states literally that were saying, okay, before you get an abortion, you have to go to this class, this 2-week training class, or you have to get an ultrasound and see the fetal heartbeat before you do it. Is that an undue burden? Right? Now, the question is, what is undue burden, right? But generally, those first 3 months are hands-off. Like, they cannot limit access to an abortion, all right? I want to say there's a Texas law right now, though, that says before you get an abortion in Texas, you literally have to have a transvaginal ultrasound, right? An ultrasound, an invasive ultrasound to see the baby's heartbeat. Because again, remember that this country, we have conservative places that are very religious and very anti-abortion. We have more liberal places that are the opposite of that, right? And so they're going to reflect the political culture of that place, right? Okay, or the dominant political culture of that place. All right, now again, Bush v. Gore basically said in the 2000 election, I'll tell you this in class, but they're counting ballots differently, and therefore they were violating the Equal Protection Clause. Let's do this in class, all right? All right. That's it, all right? Do your best, make a cheat sheet. All right, we'll take a quiz.